On Monday, the district court in DC decided Ayla's lawsuit in Purdue v. Scalia that challenges the Department of Labor's rulemaking with regard to the new wages. And essentially, we were making two arguments in that lawsuit. The first argument we were making is that the government should have gone through the proper procedures of notice and comment under the Administrative Procedures Act before implementing the rule. As you'll recall, what the Department of Labor did in this rule is they dispensed with notice and comment and went immediately to interim final rule and made the rule effective within 48 hours. And Ayla challenged that rule on two substantive grounds. The first is notice and comment, that the government should have gone through the APA. And then the second is that we made several legal challenges to the rule, substantive legal challenges based on the fact that the methodology was faulty, that it contradicted other areas of the law. And so we made several different challenges. What ended up happening with the case is that we agreed that with regard to the notice and comment claim, the APA rulemaking, that we would proceed straight to summary judgment. In other words, the court didn't need to decide the injunction or anything. We could move straight to summary judgment on that issue. What you should also know in terms of background is that there were two other cases filed challenging the wage rule. The first was filed by the United States Chamber in the Northern District of California. And the second lawsuit was filed in New Jersey by tech companies. So previous to the decision in the Department of Labor case, the Purdue case, we had two other courts that had already ruled that this rulemaking was illegal and should be set aside. So why is our decision in Purdue v. Scalia significant? Because the court went a little bit further this time on Monday when they struck down the rule. Not only did they agree with the other courts and find that the government's justifications for dispensing with rulemaking were invalid and not sufficient to warrant the good cause exception, but the court also ruled that the Department of Labor must reissue all prevailing wage determinations that relied on that rule methodology between October 8th and the date of the ruling. So that's where we are today. The rule has been set aside. We have been ordered to confer with attorneys for the Department of Justice to come up with a sensible way to reissue these wages without creating further backlogs from the Department of Labor. So you should stay tuned. As soon as we know how the Department of Labor is going to handle the reissuances, we will let everyone in Ayla know. I want to take a moment and thank all the dozens of Ayla members that helped out on this litigation, from drafting comments to assisting us with analyzing the litigation to drafting pleadings and reviewing pleadings. Numbers of Ayla members helped. Especially want to thank the Director of Litigation, Jesse Bless, and my co-counsel, Chuck Cook and Greg Siskind. We couldn't have done it without all of the volunteers from Ayla, and I'm very proud of the effort that Ayla took in this case.